ZN Afghanistan and others against the Entry Clearance Officer, Karachi.
Yes, my lords, I appear with Mr. Nicholson and Ms. Weller, Ms. Giovanetti and Ms. Broadfoot appear for the Secretary of State. Your lordships will see that of the three areas of dispute in this case, on the third area, in relation to Article 8, the Secretary of State has in fact taken action which results in that becoming now academic. The issue, however, remains important on so far as issues 1 and 2 are concerned for the appellant for a number of reasons. The most obvious of which is that, as the Secretary of State has confirmed in a letter last week, if it were to be the case that we would succeed under issues 1 or 2, in practice, whilst not making any commitments as to future policy, the position would be that the family would get indefinite leave to remain.
Yes.
So the issue is also of some importance for other cases, because in particular there is a tranche of cases which are a tranche before the implementations of the various EU directives took place. And that tranche of cases, the cases where people have been accepted as refugees in this country, have then gone and obtained nationality through a process of naturalization without anybody telling them what the consequences would be of them doing that. And they may now have only some years later managed to locate their families, and it becomes impossible for such people to actually benefit from 352A or 352D of the rules, given the Court of Appeal's interpretation. Your lordships will be familiar with the basic geography of the case. So, if I may, I'll proceed straight to dealing with the first issue, which involves a construction argument. The second issue involves the question of procedural rights, and I'll come on to that in due course. My lords, so far as the construction argument is concerned, just so that
I think, Mr. Gill, your microphone is off.
I do apologise. There's a tendency.
Yes, it's bad. It's a design fault that advocates can so easily switch off their microphones without noticing.
My lords, so far as the first issue is concerned on the approach to construction of the rules, can I first of all take your lordships to the rules themselves and then consider the just so that you have the rules, and then just consider the submissions in relation to that. The rule, very briefly, just to introduce it, is at page 100 and the current rules start at page 173 of the appendix. I'm afraid they're sideways, and the relevant rule appears at page 181. Now, I take as uncontentious the approach to the construction of these rules, so which I'll come back to in one moment. That is, one focuses on the plain language of the words of the rule, having regard to the context, and such purposes can be discerned from the words themselves. That really is the submission on construction, which is in paragraphs 27 and 28 of our printed case, and that has been dealt with on a number of occasions in this court. I'll come back to just show you some of the cases on that briefly in a moment. But the rules in question are 352A, The requirements to be met by a person seeking leave to enter or remain in the UK as the spouse or civil partner of a refugee are that the applicant is married to or the civil partner of a person granted asylum in the United Kingdom. And then, importantly, this phrase, the marriage or civil partnership did not take place after the person's granted asylum left the country of his former habitual residence in order to seek asylum. This provision is key to understanding the whole of this rule. And because what these provisions are seeking to do is, in the case of refugees, case of persons who fled their countries as refugees, to assist them to reconstitute the family lives that were in existence at the time of the flight. Not any new families that they may have collated along the way, but the disruption is what the United Kingdom seeks to put right. And we say that once one understands that that is the critical feature of these rules, it doesn't particularly matter whether the reconstitution of the family life comes about at a point in time when the refugee has moved on to a better status of having got British citizenship. Now that's 352A-D, and you'll see that 352A-1 talks about person granted asylum. 352D is the rule relating to children. And that's over the page on page 182 on the right-hand side, top right. The requirements to be met by a person seeking leave to enter or remain in the UK in order to join or remain with the parent who has been granted asylum in the UK are that the applicant is a child of a parent who has been granted asylum in the UK. And again, at 4, should have been part of the family unit of the person granted asylum at the time that the person granted asylum left the country of his habitual residence in order to seek asylum. True it is that 352E says limited leave to enter the UK as the child of a refugee may be granted, provided a valid UK entry clearance for entry in this capacity is produced to the immigration officer on arrival. The other rules I'll introduce in a moment, but those are the critical words. Before analyzing these rules further, having set out what we say is the context and the purpose under these rules, that is, to reconstitute the family lives which were disrupted as a result of the flight, we ask the court to note that what the United Kingdom has done in putting forward these rules, in adopting these rules, is to assume a positive obligation to bring together such families. Now, under the Refugee Convention itself, there are a number of rights.
What do you mean by that?
A positive obligation to bring together the...
Well, they don't need to go off. The United Kingdom doesn't need to go off and look for members of the family and insist that they come here. I mean, it all depends on whether they apply.
Well, let me put it differently. Such a duty, once it is adopted, such an obligation, once it is assumed, is an obligation which has to be interpreted consistently with the general requirement that family life needs to be promoted, and there is a positive obligation to promote it. The Refugee Convention itself, which is in the first authorities volume, we'll have to go through the rules in a little bit more detail, but the Refugee Convention itself, authorities volume 1 at tab 2, gives further indications as to the approach to construction that one should adopt in relation to rules which seek to implement matters coming out of the convention and the recommendations. So, for instance, at tab 2, page 12, I'm sorry, let me take it up at page 15, first of all. In the preamble to the Refugee Convention, your lordships will have seen these words many times. The first recital, considering that the Charter of the UN and the Universal Declaration have affirmed the principle that human beings shall enjoy fundamental rights and freedoms without discrimination. And next, considering that the UN has on various occasions manifested its profound concern for refugees, endeavour to show refugees the widest possible exercise of these fundamental rights and freedoms. It then goes on to say that they have taken measures to consolidate the previous measures and put in place this agreement. At page 16, just something to be aware of. Article 1A2, this is the original wording when it says, as a result of events occurring before the 1st of January 1951. The protocol, you'll know, removed those words to remove the temporal and geographical limitation on those words. So those words, as a result of events occurring before 1st January 1951, and later the words just at the end of 1A2, as a result of such events, those are to be ignored. And the protocol is at page 48 of this same tab, but we don't need that. Then, still sticking with the convention itself, one sees at page 26 that there are various welfare rights accorded to refugees. You see under the heading of rationing, where you have a rationing system, you treat refugees in the same way as nationals, page 26 of tab 2. And Article 21, housing, you don't treat them any less favourably than aliens. The rationing is the food, the money. At Article 23, public relief, again, the same treatment with respect to public relief and assistance as is accorded to their nationals. The effect of these provisions is, rightly, that when we allow refugees to settle in the United Kingdom, we do not impose upon them any requirement that they should be able to support and fund themselves from their own resources. Similarly, we say that when the families are brought in pursuit of the family reunion imperative, the families also are not obliged to show that they will be able to support themselves without recourse to public funds. That is why Rules 352A and D are worded the way they are. There is nothing.
You don't get that out of the convention, though, do you?
You don't get it out of the convention. I accept that.
Indeed, there's nothing in the convention which supports that at all, is there?
Well, it doesn't deal with this. I fully accept that. But what I'm saying is it would be consistent with that.
On the contrary, it simply tells you when you stop being a refugee. At page 12 of the same tab is the principle of unity of the family. Now, this is a recommendation which has then been taken up by states and obligations have been assumed in pursuance of it. And it says that considering the unity of the family, the natural and fundamental group unit of society, is an essential right of the refugee, that such unity is constantly threatened. So it's an ongoing scenario that will presumably arise whilst the refugee is in a state of refugeehood. It goes on to say, noting with satisfaction that according to the official commentary on the Ad hoc Committee on Statelessness and Related Problems, the rights granted to a refugee are extended to members of his family. And that's why, my Lord, I was saying that the approach is that the same rights that the refugees would get are to be rarely transferred over to the families so that they're able to be reconstituted as families in the state of refuge. It recommends governments to take necessary measures for the protection of the refugee family, especially with a view to ensuring that the unity is maintained, in particular in cases where the head of the family has fulfilled the necessary conditions for admission. colleague has, and then focusing particularly on minors. Then there are certain welfare services considerations as well, but they don't add significantly. Now, consistently, although, as my Lord says, Convention doesn't directly deal with it, consistently with that, the international community has adopted rules for family reunion in different ways, but the basic minima has always been respected. The rules themselves, we say, as drafted, and these submissions are set out in our printed case, which I take as read and adopt. The rules as drafted, going back to the rules at page 181 of the appendix, do not draw any distinction between.
Is it 181 or 173?
It starts at 173, my Lord. I apologize. In fact, front page isn't here, but it starts at 173, but which is part 11 of the current rules under the heading of asylum. But the relevant rules at 352A and D are at page 181 and 182.
So the current version begins at 173, is that right, Mr.?
That's right.
Thank you.
So page 172 is a previous version,
Yes,
is it?
because it refers to spouses and things like that.
Yes.
Basically, if I can put it like this, pages 165 to 168 are the rules as at March 2005, when the applicant obtained naturalization, when the sponsor obtained naturalization. But for our purposes, the rules are, there's no material change. At 169 to 172 are the rules as at 7th of July 2006, which is the date of the entry clearance officer's decision
So that was
to refuse entry to the family.
169 to 172
Is the are the rules as at 7th of July 2006, when the ECO refused entry clearance to the family. And 173 to 184 are the current rules, which have added in a number of other provisions, but for our purposes, the relevant rules 352A and D are the same. I think the respondents, if I can just explain why, wanted the different versions in to show how it is that over time certain procedural rights have been brought into the rules, obligations to give notice and so on. But so far as the substantive provision is, and that may be relevant to the second issue, but so far as the substantive provisions are concerned, that's been the same throughout. And that's why I've stuck to the current rules, particularly because your Lordship's judgment perhaps has, whilst it has obvious relevance to the applicant himself, also has relevance for future cases. Lords, we say that these rules, 352A and D, focus upon the position of the applicants, not on the current status of the sponsor. The opening words, the preambulatory words of each rule are not the words which actually define the requirements that need to be satisfied. The requirements that need to be satisfied, for instance, in 352A, are the ones which are in Roman numerals, little Roman numerals 1, 2, 3, 4, and 5. The opening words are simply the broad category, the label under which a person is seeking to seeking the document, the entry clearance. But that which actually has to be satisfied, the criteria, is set out in 1, 2, 3, 4, 5 following. And that's the structure also in all the subsequent rules. If one looks at 352D, for instance, again also the structure is exactly that. And again, when one goes to 352FA, which has been now inserted at page 182, requirements to be met by a person seeking leave to enter or remain in the UK as the spouse or civil partner of a person who has been granted humanitarian protection in the UK on or after 30th of August 2005 are that, then certain specific criteria are set out. If you satisfy those criteria, you're in. If you don't, you're not. And that's what needs to be focused upon.
Yeah, but you have to satisfy the status provision in the first 3 lines, otherwise you don't reach little one.
Well, the state it's not like that, my lord, because the provision in the first part of the rule is not a status provision. All it is it's not looking for a current status that the sponsor must possess.
Well, on that point, refugee status is a well-recognized concept. Is there a similar concept of humanitarian protected status?
There is now, my lord. That's why this rule was added in.
As status?
As status. It comes because of the directives, has brought in this concept of not just the refugee status, but a subsidiary protected status, humanitarian protection, which we've labelled it as. But that subsidiary status is exactly that. So it's a status. There is a distinction, of course, to be drawn between being a refugee, being recognized as being a refugee, that is, someone says, fine, you have the label of being a refugee, you have refugee status, and of having something in pursuance of that is the asylum. Simply being recognized as a refugee is no good to a refugee. It doesn't give him anything. What he's interested in is the actual grant of asylum. That is what gives him some form of protection, some form of security. That gives him access to all those welfare provisions that we looked at in the Refugee Convention.
But putting it very, very simply, you say that a person who came as an Afghan refugee and is subsequently granted British nationality can still be described in ordinary parlance as an Afghan refugee, just as Klaus Moser or
Absolutely.
Dr. Mann or Professor Lipstein could be regarded as German refugees when they were in their 80s.
Absolutely.
Having been granted British nationality 40 or 50 years before.
As one of the immigration judges very clearly put in, the immigration judges, with respect, have got it, we say, absolutely right. About all of them, apart from one decision, have been consistently interpreting the rules very simply and clearly, focusing upon the critical point as to what it is that these rules are seeking to protect. They're seeking to reconstitute the family life that existed. Even though your current status may change, the state may say, you came here as a refugee, you gained a form of asylum, we call it leave to remain or indefinite leave to remain or 5 years leave to remain, whatever it might be, it could be anything. Different states do grant asylum in different ways. Now, we, under Article 34 of the Refugee Convention, which I didn't show you, but I'll show you in a moment, we also recognize we have a duty to facilitate your naturalization, get you integrated into the country, move you on to nationality status. Yet, when you do that, somehow your rights to family reunion are going to become weaker, even though it may be, and we know, practical experience tells us, that when a family is sundered as a result of persecutory acts, they could be spread all over the world, and sometimes it takes some years for them to be reconstituted. In the meantime, what is the refugee in this country supposed to do? To say, well, hold on, I will not take the benefit of what you, the state of refuge, are trying to do for me, to push me along, rightly, into integrating and becoming a naturalized citizen. I will not do that, because if I do that, I won't actually be able to get, because you'll say my status has changed, that I will therefore not somehow be a refugee who is no longer sundered from his family. It just doesn't make sense.
But you're not saying that it would be unlawful or breach of the United Kingdom's international obligations anyway if the rules plainly meant what the Court of Appeal said they meant, are you? I would be open to the Secretary of State to have such a policy, wouldn't it? The question is whether he did.
My Lord, I'm not sure that I would accept that. I fully understand your Lordship's point that the Refugee Convention doesn't directly deal with this, of course. But the position now, 50 years on from the Refugee Convention, is that the right to family reunion, recognized in a number of different international provisions as well, such as the ECHR, but that's a general right of family reunion for third country nationals, subject to limitations. In the context of refugees, has reached a level where we recognize, and the European directives make this clear, that the limitation that you can impose on this can't go further than putting it at the point of the family members that were pre-existing. The EC directives make that clear. States can impose a limitation, but the limitation must, it says that they may limit this right to family reunion to those families which were pre-existing. And that's why I say, it would be actually contrary to the directives if the Secretary of State
that's
were
a
not to
different
take
point.
that approach.
That's the directive point. But leaving the directive on one side, you've never said so far, have you, that it would in some way be breach of the United Kingdom's obligations to introduce a policy of the kind which the Court of Appeal held to have been introduced.
My Lord,
I quite understand if the directive point's good enough for you, well, then it's good enough for you.
my Lord, the current directive point, the purpose for which I'm using the directive at the moment is different to the directive point as it appears in the printed case. The directive point as it appears in the printed cases is about procedures for when you cease to be a refugee. The point I'm making at the moment is a different one altogether. The point that I'm making at the moment is that it is a recognized principle of international law, at the very least within the European area, that you cannot have a rule which prohibits the coming together of the pre-existing families of refugees which were pre-existing at the time of flight. You cannot have that.
Sorry, is there anything in the directive which prevents that?
Which supports what I say.
Yeah, it prevents a country having such a rule.
Well, the directives are at...
185, and I know where they are. The question is there anything in them which actually prevents a country having such a rule?
Which provision is it again? Sorry. 193, I am grateful. The Article 23 on maintaining, page 193, on maintaining family unity. They set out what has to be done, shall ensure, etc. 23.2. The limitation appears at 23.5. So they can draw the line at that point, but they can't do it at some earlier point in time. I don't take this to be a contentious point. The effect of this provision in Article 23 is that it would be unlawful for the Secretary of State to devise a rule which actually had the effect of limiting the pre-existing family members coming to join the refugee, and we say, even if the refugee subsequently acquires British nationality.
Well, this directive raises exactly the same issue of construction, doesn't it? Because it talks about family members of the beneficiary of refugee status. So the same question arises if you've no longer got your refugee status because you've got something better. Do you lose the rights which you did enjoy as somebody who's beneficiary of refugee status?
Well, you'd think it was better, but
yes, you'd think it was better.
But the way in which the directive deals with this, if I can just put it in a couple of sentences, is to say your refugee status doesn't in fact cease automatically. You have to have certain procedures before it ceases. That's why this becomes more relevant to issue 2. It has procedures, for instance, in Article 11 and Article 14.2, which then cross-refer to the Procedures Directive. So in Article 11, what they say is that you shall cease to be a refugee. I should say that at page 187 are the definitions. Refugee means, at page 187, such and such, we know what it means from the Refugee Convention. But refugee status is something different to being a refugee. The status is the form of recognition. You see that on page 187 on the right-hand side in the definitions. Definition of refugee and refugee status. So once you can have that refugee status, it is, and that has to carry with it certain protections. That can only be taken away from you according to the scheme of the directive if certain procedures are followed. Article 11 says the person shall cease to be a refugee. True, in law, a person may cease to be a refugee when these events occur. But the question is, how does one begin to then say, well, you've lost your refugee status, you've lost the protections, the asylum and all the other protections.
But under the directive, if you cease to be a refugee, have you lost your refugee status?
No.
You haven't?
No. Because you
Where
see
do we
under
see that?
Chapter 4, which is on 191, Article 13, you grant refugee status and you revoke it, Article 14. There is a clear process for granting and revoking. And that must be so. I mean, people can, in law, be your, certain things, but laws require procedures. They're meaningless without procedures, because it's through the procedures that one gets the substantive benefit. And what this says is that states shall grant Article 13 to persons who qualify as refugees, and at Article 14 that shall revoke and or refuse to renew the refugee status, but it requires a positive act. That's what Article 14 is talking about. 14.2 says, without prejudice to the duty of the refugee in accordance with Article 4.1 to disclose information, etc., member state which has granted refugee status shall on an individual basis demonstrate that the person has ceased to be.
So you can cease to be a refugee, but still have refugee status until it's revoked in accordance with Article 14. But you're no longer a refugee, even while you have the refugee status, on the terminology used in the directive.
That's right.
See paragraph 1.
Yeah.
But isn't Article 14 dealing with taking away refugee status of somebody who hasn't got the preferred status now of citizenship? When the examples given of revocation, and the same with exclusion. So that you're revoking refugee status, where the refugee has got that status, but you're taking it away from him. It's a different thing where he himself has ceased to be a refugee without any revocation. Isn't that right?
Well, what your lordship is perhaps postulating is that there may be certain acts that a refugee commits voluntarily, which puts him in in a condition where he's no longer a refugee.
I mean, it's a startling proposition that everybody who's been given British citizenship who was a refugee has got to have his refugee status formally revoked. I mean, that's what you're saying, isn't it?
Under this directive, that's what happens. And that's exactly the position. The 14, there are good reasons for that, my lord. States are obliged to give to refugees some stability, some durability of protection. There is nothing wrong, nothing inconsistent with the Refugee Convention for states to say, what we will do is to give you a form of protection. That is, 5 years leave to remain, maybe indefinite, whatever the state chooses to do. But we recognise that a point may come when you actually become a national of our country. We're not going to take away the protections that come with the status that we have accorded you. We are not going to do that, and if we do that, we will do it through a process. We will revoke, and we'll give you notice. We'll give you a chance to say why that shouldn't happen. That's what, and some of the academic commentary that I'll show you in due course is consistent with that. That's what this directive is saying. You put people in that position of certainty.
What if you're a refugee and you no longer wish to have the status? Can you only lose that by a process of revocation?
If you're a refugee, you've got refugee status, you've got it in the form of indefinite leave to remain, and you want to give it up, I would, and the process, it's difficult to imagine the circumstances in which you would want to. The only one that I can think of is that you would want to actually become a national of the particular, of another country. Now, in those circumstances, I think I'd have to accept that you could lose your status through such an act, but only if, first of all, there is a certain procedure followed. There are two. This is really more relevant to the second submission rather than to the second issue rather than the first.
But just take Article 25, for example. It's completely contrary to common sense that somebody has become a British subject and therefore ceased to be a refugee under Article 11 can still ask for the travel document, Article 25.
Absolutely.
Well,
I mean, the whole idea of this is, in terms of the refugee himself, is that he first of all he seeks asylum. If he's given leave to remain, so he has the status of a refugee, then the whole idea of this is that when he gets nationality, he has all the benefits that a refugee would have, so he doesn't need refugee status anymore. Now, I quite follow that the family position is different, and we need to look into that. But that's the whole underlying basis of this, is that nationality will replace the refugee, his refugee status, because the whole point of being a refugee is to obtain new nationality if you can, to replace your original nationality, because it's too dangerous to go back to your original nation. And so, on the face of it, one would have expected the status, subject to your procedure point, to be replaced, status of refugee, to be replaced by that of nationality.
Well, as I said a moment ago, yes, provided that there is some form of procedure.
Well, that's the procedure point.
That's the procedure point, absolutely.
But there's no wider point than the procedure point.
But this doesn't mean you're wrong on the construction of 352A.
It perhaps emphasises the need to focus on that.
Your best point is the refugee means refugee, and they, well, what more do you want? The one that my Lord Collins put to you a few minutes ago, except that, of course, the refugee in ordinary language has to be a refugee who's claimed asylum and be given asylum. Yeah. You can't include every refugee in ordinary language who haven't. But that's because you have to comply with the various little paragraphs, sub-paragraphs.
This is more relevant to the procedure issue. Going back to issue 1, if I can, and focusing on the words of the rules themselves, page 181.
This is entirely down to what's meant by refugee with a small r in the 352A, is it?
Well, the argument, we say it's really quite straightforward, that the requirements are set out in 352A1.
Yeah, but you have to be the spouse of a refugee before you reach little
My
one.
Lord, the simple
So the question
answer
is
to
whether
that.
you're a spouse of a refugee or not.
Simple
if you are, then you're okay, and if you're not okay.
The simple answer to that is that if I am as one of the immigration judges put it, the child of a factory worker, I am the child of a factory worker. I'm the spouse of a factory worker. Now, this is well explained.
You're a child of a factory worker, even if by then your father's become Prime Minister, you mean?
Indeed. The point has to be understood by reference to this provision that the family should not have come into existence after the point that you left. That's the critical point that one has to always focus upon. That's why it doesn't make any difference whether your father's become what's happened later. The point is you're trying to reconstitute something that was broken apart some time ago. It was broken apart at a time when you clearly were a refugee. You've had that refugee status for a period of time. You're still trying to bring the family together. Why is it that it is obligatory to read those words as a refugee to mean a current status? There's nothing in those opening words to say it has to be a current status. These rules are to be interpreted.
My point was not that. My point is that in ordinary parlance, someone who was a refugee remains a refugee.
In ordinary parlance, that's absolutely right. And the best way of explaining it. Don't mix up my. Sorry. I want Perkins.
That's self-explanatory proposition. We can presumably all decide what the position is in ordinary parlance without recourse to the authorities or the learning.
My Lord,
You only need the learning to find out what's the position not in ordinary parlance.
my Lords, in volume 5 at tab 47. Senior Immigration Judge Perkins, we say, explains it absolutely clearly in a short and clear determination of no more than 4 pages. And you'll see that he sets out the rules in paragraph 4, and he notes that in paragraph 5, you see he's referring to 352D there. And 352D there doesn't contain the words as a refugee. It contains the words in order to join or remain with a parent who has been granted asylum.
It originally said as a refugee.
Yeah. And the words set out in the square brackets were substituted from 18th of September.
Well, he makes the point in paragraph 13, the factory worker point, but that is a different point. To say somebody is the child of a factory worker who's now the managing director or prime minister it's a slightly different point. The point that I made, I'll make it just once more, is that in ordinary language, a person who was a refugee is still described as a refugee today, even though he or she, several years ago, might have been granted nationality.
Yes, yes. I suspect that's what he's trying to...
No, because the factory worker, who's prime minister, is no longer described as a factory worker.
And paragraph 10 of his judgment is the opposite effect.
Well, fair enough. I see the distinction. He goes, but in the intervening paragraphs on other points of construction, he makes clear. Paragraph 7. In this case, the parent's father was recognized as a refugee.
I mean, paragraph 11 is against you, isn't it?
It's not against me, my lord. All it is saying is he is not currently a refugee within the Refugee Convention definition. It's not against me in the slightest. It is because we entirely accept that the man is not currently within the Article 182 definition of refugee that the argument is as it is. And at the next tab...
Well, if you fulfill all the requirements of 352A, little 1 to 5, all the relevant requirements, you get in, do you?
Yes.
Irrespective of how you're described in the heading of the things.
Yes.
And what they require, you have to show you're married or civil partner of a person granted asylum in the United Kingdom.
That's it. Those are the requirements. That's the critical feature. And all that the opening words of each paragraph are saying, and this runs throughout the rules, leave to enter as a businessman, leave to enter as the wife of a student or whatever. Sometimes people are seeking to enter at the same time. But, these are simply convenient labels. If there was something more than that to them, if they were actually important, one would actually expect them to be consistently worded. They're not consistently worded.
But that's not the basis of Judge Perkins's view. His view was he was construing paragraph 352 capital D, and it's far from clear to me that he would have construed 352 capital A in the same way, because he says that there was a change of word. He was construing he was saying that the defendant's father is not a refugee within the meaning of capital A, as I read it, but he's saying that he is a person who's been granted asylum within paragraph big D. That's what he was saying.
Well,
and that doesn't prove enough for you.
Well, it would be rather odd, my lord. And
I quite see that you can say that actually this is a point of what they must have meant by refugee, because when they changed it to in little big D to say has been granted asylum. It's inconceivable that they meant something different in big A. And since has been granted asylum is quite clear, we must construe refugee consistent with a big D.
Yeah.
Apart from my little comments, consistent.
We had some of the same sort of problems of interpretation in the case of Mahad, which some of your lordships will recall, where the rules are not all worded consistently. And there is a...
No, we'd be out of a job if they were.
But for my purposes, the critical parts, that is the requirements themselves, are consistent. The opening words are not, but insofar as the opening words of 352A and 352D are not consistent, I say that one needs to look at the opening words of 352D to understand what is meant. On that point, what the other side say is this. They say that these words in 352D, in order to join or remain with the parent who has been granted asylum, the opening words, they say that those words must have been introduced in order to meet a child protection concern. Because in the case of Rule 297, which was dealt with in the case of Mahad, the children rule, there was a change, or in one of the children's rules there was a change, but not in all of the children's rules. There were inconsistencies, as your lordships, these three of your lordships will recall from Mahad, about that. And they say that therefore what this is really getting at is to emphasize that the child should be coming to join or remain with the parent who's been granted asylum, and it is trying to meet a child protection concern. We said that may explain the words in order to join or remain. That is, you're actually coming to join or remain the action and not somebody else. But it does not explain the words with the parent who has been granted asylum. If that was the real reason, what the words should have read is, in order to join or remain with the parent who is a refugee. That is not what the words say. So their attempt to say that this change is a change to meet a child protection concern, and therefore the governing principle still remains that the person must be currently a refugee, consistently with Article 352A, cannot actually explain those words, has been granted asylum, because at most it only seeks to explain the words in order to join or remain. And once that point is reached, once that is if it is accepted, then we say means that the introduction of those words in 352D, far from being any form of neutral factor, because I said a moment ago that the opening words of the paragraphs are not really what tells you very much. In fact, if what I've just submitted is right, then far from being a neutral factor, those opening words of 352D do actually tell us what is meant by the words a refugee in 352A, opening words. It means precisely what is meant, what is said in 352A1, that is, a person who's been granted asylum. Has been granted, doesn't mean he has to have...
Focusing on a past event, providing the past event is satisfied, you're in.
Yeah.
Yes, and it's quite plain that is the right approach to, for instance, 352FD, a person who has been granted humanitarian protection.
Yes.
Because little 1 says deals with a person granted humanitarian protection on or
Absolutely.
after. Absolutely. So it's focusing on specific event.
Absolutely. It's focusing on a one-off event which occurred some point in the past, that is the grant of asylum.
Lord Justice Law is talking about it has been raining. Raining is something that can happen rain is something that can happen over a period. Being
Yes.
granted something is something that happens at a specific point in time.
Absolutely, my lord. Those submissions are set out in our printed
Yes.
case at paragraphs, if I can turn to that, at paragraphs 39 to 42. And if I can just take a moment to go through that.
Well, this is just the aorist against the
Yes.
the past perfect test.
Yeah,
I think
well,
we've grasped that. I mean, you say that you can say it has been raining last night, just the same as it rained last night. So there's no distinction between them.
Yeah.
In order to make his point, he's had to add since last night. It simply tells you what the position is now.
That's right. That's right. And so, when one looks at the plain word, it's I mean, a very prosaic example. If I say, "I have killed Joe," it's an event that occurred some point in the past. If I say Joe has been killed by me, has been killed, it's still referring to a past event, not a continuing state of affairs. He's just as dead. The grant of asylum is what we have done to this individual, granted him asylum. Once we've granted him asylum, we recognize the pre-existing family needs to be preserved. We know he may take time to find them. We know that we want him to become a national. Are we going to put him in a worse position because he becomes a national? The rule cannot have meant that. That's all the immigration judges, apart from one, prior to this case, thought that it was as simple and as clear as that in our favor, suggests that if these rules are to be interpreted in accordance with the principles set out in Mahad, plain and clear language in the way that the rules are intended to mean, put forward simple words that simple, ordinary people can understand, not lawyers. This is supposed to be understood by immigration officials who are not trained lawyers and by people who are going to be relying, the customers, as it were, who are going to be using these rules. They would approach these words of a refugee who has been granted an asylum in exactly the same way as, with respect, my Lord, Lord Collins puts it. That's how they would see it. Secretary of State, and that's how the immigration judges have seen it, Secretary of State says, well, no, what I actually meant was something else. Well, if that's the position, we say, bearing in mind that this is a fundamental family right arena that we are working in, he ought to have used express and clear words, which Parliament would then have had the opportunity to debate if the rules had been put in front of Parliament. He didn't do that. He's now seeking to put a gloss on those words, which isn't actually within the words themselves. And there is now a significant tranche of people, before the directives have now made the position, we say, clear and protected people in a different way by setting up procedures. Before the directives, there's been a tranche of people who've been encouraged to move along the path to naturalization, because we now only
We're coming on to rather different considerations, which is the trick or the deception argument.
That's right.
The points that you've made on construction are very simple, straightforward points, and we're inclined to think it would be a good idea if we heard Miss Giovanetti on those points, because if you're right on them, we don't need to go any further.
I'm grateful.
The point raised by Lord Collins was the point that occurred to us in the preparation of the case, and we had some discussion about it.
I think you'll have to go on your life.
if I need to repeat that, but the point about ordinary use of language was one that occurred to us in the course of preparation of the case, and we did have some discussion about it. And I think our answer would be twofold. Firstly, we wouldn't accept necessarily that just giving the language its ordinary meaning, a person who was once granted refugee status but is now a British citizen could properly be described as a refugee. Miss Broadfoot had a member of her extended family who came to this country decades ago as a refugee, and she tells me she'd be rather offended if she was referred to as a refugee. She regards herself very firmly as a British citizen and is very proud of having acquired British citizenship. Not Miss Broadfoot, her relation. And
It's an unalterable part of the history
yes,
of that individual,
she'd
isn't
say
it?
she came as a refugee. She wouldn't currently describe herself as a refugee. And then I discussed the matter with some other people that I know who came as a refugee or whose parents came as a refugee. And opinion was fairly divided amongst those who would still regard themselves or whose family members would still regard themselves as properly described as a refugee and those who wouldn't. So while I accept that a lot of people might use the word refugee to describe anybody who originally came on that basis, I wouldn't accept that it's plainly and clearly the natural meaning of the word.
It's a natural meaning.
It's a natural, but not necessarily the natural meaning of the word, or the only natural meaning, is the first part of my response. And the second is that we are, of course, dealing with a legal instrument here. And the word refugee is one that has an accepted definition as a matter of international law. And it would be surprising if the use of the word refugee here was not intended to reflect the definition as an established matter of international law. Because trying to look at it in terms of ordinary language has great dangers. For example, an ordinary person might regard anybody who came fleeing civil war as a refugee, quite understandably. But we know that as a matter of law, somebody who came to the United Kingdom fleeing a civil war will not necessarily be a refugee, depending on whether or not they fall within the terms of the definition. So in my respectful submission, it would be preferable to give the term its legal meaning rather than attempting to identify the correct ordinary meaning of the word. That's what I'd say about that point. Now, if my lords are against me on that point, the rest of my submissions really fall away. But if my lords aren't, I know quite a lot of them like the opportunities to say about the true international meaning and the meaning of the directives and their application. But I don't know if it's best if...
I mean, the sponsor was undoubtedly at one point a refugee.
Yes.
He was a refugee before he ever reached these shores.
He was. He wasn't recognised as one, but he was one. As soon as he left Afghanistan.
Absolutely. And what actually matters is whether or not he was granted asylum.
Well...
in the United Kingdom, because it's only if he's granted asylum. So the critical thing is that he's a person who was a refugee and who was then granted asylum.
Yes.
That's what matters. It's really that's really what matters.
Well, my lords, as I understood it, that was Mr. Gill's principal point. He attached no weight at all to the use of the word refugee. They're two really rather different arguments. The first is that you ignore the word refugee and you simply ask, has there been a grant of asylum? The second is that one does look to the word refugee, but it depends, a lot turns upon what meaning one gives to it. I was trying to address the point about looking at things in the context of the word refugee, but giving it its ordinary meaning. The other argument, that you ignore that and you just look at the first requirement, has a slightly different answer. We would say, firstly, taking our submissions in the reverse order to the way they're put in the case, but firstly, that would lead to really rather absurd results. I mean, very absurd results in some cases. Because if one just looks literally at the question, has the sponsor been granted asylum, that would cover people who've been granted asylum and the grant of asylum was subsequently cancelled. It would also cover people who'd been granted asylum and the grant of asylum was revoked because they came within one of the exclusion clauses, which is why you can't simply literally ask the question, has there been a grant of asylum? One has to look at it in the context of the whole of the rule, including the phrase leave as the spouse or civil partner of a person, of a refugee. So we say looked at in context, the rule is trying to address family reunion. It's looking at reunifying the families of refugees.
In effect, your argument is to the effect that there is a requirement that the sponsor has the current status of refugee. Is that right?
Yes.
Why was that not articulated as a requirement in 352A? 352A says that the requirements to be met are, and then they're listed. Why was that not listed as a requirement?
Well, again, this is something we've addressed in our case, but if I can just try and deal with it on my feet. But the reason the words were chosen as they are in requirement 1 is because, as we've heard, somebody is a refugee, as my Lord Rogers says, as soon as they leave the country of their nationality because of a well-founded fear of persecution. So if the requirement in, sorry, can I just go back to the rule 352A1, if that was worded, the applicant is married to a refugee, it could apply to somebody who hasn't yet had their refugee status determined, because you are a refugee from the moment you leave your country because of a well-founded fear of persecution, but you only get refugee status once you're recognised.
Well, that could be easily catered for. Married to a refugee and is a person who has been granted asylum.
Yes, it could. I mean, I'm not suggesting that the language could not be clearer, but this is the language we have. And doing our best to understand what was intended by this rule, we say you have to look at the rule as a whole and look at it as part of this scheme which deals with granting leave to family members of refugees. So
it does seem slightly anomalous that this extra requirement is not contained in the list.
Now, it could have been added to the list, but we say giving the words their ordinary meaning and applying a common sense approach to 352A as a whole, reading the requirements in the context of the proviso, what we're dealing with is applications to enter or remain as the spouse or civil partner of a refugee. And it would be very strange if one applied to enter or remain as the spouse or civil partner of a refugee when one wasn't the spouse or civil partner of a refugee, but simply of somebody who had at some point in the past been granted asylum, whether or not that's been cancelled, revoked, or overtaken by the grant of British citizenship. And in fact, the words of the proviso are echoed in 352B, which again says limited leave to enter the United Kingdom as the spouse or civil partner of a refugee may be granted, provided, and then it refers to the requirements. And 352C, limited leave to enter the United Kingdom as the spouse of a refugee is to be refused if. So we're dealing with a scheme here for the spouses and civil partners of refugees.
Yes.
And what is the why should the policy be that, I mean, if the policy favours generously bringing these families together because the person is driven out of the country, has no choice, and what is the policy for saying that when that person becomes settled, those considerations no longer apply?
Policy, I think, is that you don't have two classes of British citizens. It's that somebody opts to become a British citizen, and when they do, they acquire a bundle of rights that they didn't have as a refugee.
But the only reason they're here acquiring this status is because they were driven out of the country of origin.
Of course. And my Lords will have probably seen the correspondence and seen in our written case why it is that the Secretary of State conceded the point under Article 8. Because we accept that in those circumstances where somebody, not simply somebody who inadvertently applies for naturalisation because they don't understand the consequences, but for example somebody who applied for naturalisation and then found out about a family member they hadn't previously been able to trace. There will be cases like that. And it's Article 8 that enables the entry clearance officer and in due course the immigration judge to look at the entire history of the family, and it will be a relevant factor, of course. Nobody's suggesting that you can't have family reunion. The entry clearance officer's case is that when you're dealing with an application by family members of a British citizen, you apply the rules applicable to British citizens. In the ordinary course of events, that requires that there be maintenance and accommodation for the family members without recourse to public funds. But then there will be cases where it would be a disproportionate interference with the Article 8 right to respect for family life to impose a requirement like that. And it's Article 8 that fills the gap. So we say it doesn't lead to any unfairness.
But what's the policy? I mean, on the basis that these rules are limited to people who had the relationship with the sponsor at the moment they left their previous country, and that's the only moment at which you're, well, unlike Article 8, which is looking at the current position, these rules are limited to family members at the moment of breakup, or rather at the moment they leave the country. And they have rights, at any rate putative rights, and why, which they can exercise by making an application, why remove those rights by the mere fact that the sponsor has become a British citizen? One would have thought that all the considerations which gave the families of the sponsor their rights to apply to become, to apply for these benefits were just as valid before and after the sponsor became a British citizen, because the British citizenship only tells you about the sponsor, it doesn't tell you about the others. So there doesn't seem to me, at least, to be any policy reason for removing those rights.
No, I mean, I appreciate what my Lord's saying. I didn't say
and so why can't one simply say, well, it's Parliament obviously, or the draftsman obviously appreciated that because he made it plain of Sir Pikestaff in little D.
Well, my Lord, I'd
I mean,
say
that's a legitimate aid to construction of the regulation in its present form, isn't it? Because if you just looked at D by itself, the argument would be really very difficult. See Judge Perkins.
yes. Well,
Not perhaps by contrast with A, but which is what he did.
no. Well, if that were correct, one would have a system where, for some reason, the Secretary of State had intended in enacting these rules to have one approach to the children of
I'm not suggesting that. I'm using D as an aid to construction of A.
Yes.
I'm not suggesting that. I quite follow that it wouldn't be coherent to construe them differently.
No, it wouldn't be coherent to construe them differently. And if that's the case, one asks, well, why change D but not A? And
to make it clear what A meant, perhaps. Or because they weren't sufficiently awake, or another.
Well, that's a possibility, I suppose.
As you know, Ms. Germanetti, better than anyone, that these rules are far from a perfectly drafted document.
My Lord, I don't know about knowing it better than anyone, but I'd accept that proposition. We haven't said that there is only one answer to this, but it did seem to us that the most obvious and logical answer was that which was put forward to the Court of Appeal. And I wonder if we could just briefly go to our case on this. I'm sorry, I'm jumping around a bit, but I'm trying to respond to the various points that are being raised. And we deal with 352D.
Paragraph 38.
Yes, my Lord, thank you. And it's really paragraph 43 that deals with this point, 43 and 44. And as you'll see in paragraph 43, in October 2000, there was a very similar change to the wording of paragraph 297 of the rules. That originally contained a requirement that the child can and will be maintained and accommodated adequately without recourse to public funds in accommodation which the parents or relative own or occupy exclusively. And then that was changed to a requirement that the child can and will be accommodated adequately by the parent, parents or relative the child is seeking to join without recourse to public funds in accommodation which the parent, parents or relative the child is seeking to join own or occupy exclusively. And there was some debate about the significance of this before the Court of Appeal in AM Ethiopia, which was one of the entry clearance cases where I think a bundle of them came before my Lords just at the end of 2009. And in fact, it was counsel for one of the appellants who'd had made a request to the Home Office for the reason for that change. And the response came, as set out in paragraph 44, that the wording was changed so as to be consistent with the intention and spirit of the category, that the child is coming to the United Kingdom to join and live with their parents or relative, not simply coming on the basis of the parent or relative status.
Yeah, it was a child protection.
And I think my Lord's described it as a child protection point. This is a very similar change in the wording of the rule. And we're dealing here with one set of rules, dealing effectively with family reunion. And if the intention had been that children could come to join a parent who had at any point been granted asylum, but spouses or civil partners had to join somebody who was a refugee, one wouldn't expect to find it that change introduced by this form of wording. So we say that probably the most obvious reason for changing is as part of this idea of making sure the rules reflected that they were intended to bring families together rather than just to confer status because of the status of another family member. So it's about families joining each other. My Lords will have seen our general submissions on the language of the rules start at paragraph 14 of our written case, that's page 6. My Lords, we say that the purpose of these rules was to facilitate family reunion, which is a right which, well, it's not a right in the Refugee Convention, it was quite rightly said. It was a recommendation by the final act of the conference, but it is something that most signatory states have adopted, and I think we see that in the handbook itself. We have 7 of the authorities bundle. If you can just go to that very briefly. Volume 7 of the authorities, sorry, volume 7, tab 65. So the handbook isn't paginated. This is paragraph 183 within the section headed Chapter 6, the Principle of Family Unity.
I'm sorry, which paragraph again, please?
It's paragraph 183, my Lord.
Thank you very much.
What's said there is the 1951 Convention does not incorporate the principle of family unity in the definition, but the above-mentioned recommendation is the final act of the conference, and that's the recommendation which the Court alludes to. They're referring to paragraph 182, set that the final act of the conference, which we always looked at. In recommendation, the government's take the necessary measures for the protection of the refugees family. Going back to paragraph 183, the above-mentioned recommendation in the final act of the conference is, however, observed by the majority of states, whether or not parties to the 1951 Convention or to the 1967 Protocol. So whilst we wouldn't accept that there is a requirement under the Convention to promote family reunification, it is a recommendation, it's something that we do, and it's something the majority of states do.
And does this contemplate that the members of the family will themselves obtain refugee status?
It does, yes.
And also it's limited to, is it, to those who are members of the family at the moment that the first refugee, if you like, became a refugee?
Well,
Or is that not clear?
it envisages two situations, really. It envisages the whole family travelling together.
Yes.
One applies for refugee
Yeah.
status, and the others, and it's, I think, the most common situation. The others apply to be considered as dependents. They can apply in their own right, but very often they're trying to be considered as dependents. Then 186 says the principle of the unity of the family does not only operate where all family members become refugees at the same time, it applies equally to cases where a family unit has been temporarily disrupted through the flight of one or more of its members. That's this situation.
Yes, but it's talking about the family unit as at the moment, a historical family unit.
It is, yes, one sees that by the reference to
Yeah.
the family being disrupted through the flight of one of the members.
Could you put your microphone on again? I think you've probably...
My lord,
Yes,
I
we can
apologise.
hear, but you're also on closed-circuit television.
Yes, or not.
Or not.
So, the handbook, of course, is guidance, and it's a guidance in particular with reference to the international state practice. But we'd say the important fact here is that what it's giving guidance as to is a recommendation, not a convention obligation per se. And the recommendation is that the necessary, it's very loosely worded, the necessary measures are taken for the protection of the refugee's family. So that can be done in all sorts of different ways, and indeed it is. And state practice varies enormously as to what's
But there's
done
no suggestion that that should somehow cease if the sponsor becomes nationalised in the new state, is there?
Well, my lord, it's not that that should cease.
So, I
but
mean, it
that we-
doesn't really support you, does it, particularly this, or possibly them? I would have thought on balance it supported them, but
No.
probably nobody.
Lord, no. I'd say it does support us because what we're looking at here is the rights and incidents of refugee status, and that's what family reunion is about. Nobody's suggesting that if the refugee then acquires a national status and becomes a British citizen, that the family should no longer be allowed to be here. But the concept of family reunion applies to a person who is a refugee. And that's what these rules are intended to do. We have a separate set of rules for people who
But
are
not to
British
somebody
citizens.
who's got a better status.
Exactly. Yes. Sorry, can I have some? The construction point really is quite a short point, I think, as my lords have said to my learned friend. I'm not sure there's much more I can add on that.
Should we do a break?
But
Yes. Should we come back? Yes, yes. Mr. Gill, is there anything you wish to say in reply on construction?
My lord, there isn't really much else, I think, to say other than what's already in the printed case, and just make the one point that given that my learned friend accepts that the construction that we contend for is a natural meaning, but not the only natural meaning, even if one approaches it only on that basis, I'd ask you to apply the large and liberal spirit that Lord Hope called for in the construction of, at paragraphs 7 and 8 of the Hoxha case, which is at tab 29 in the interpretation of provisions which are adopted in pursuance of the convention. And on that approach, we say that our construction should be adopted.
What do you say about that point, first of all, about the anomaly? What about the problem of the status being revoked?
My lords,
Either because, well, for whatever reason, either because of some fraud or for some other reason.
well, the points in relation to that are fraud is something else. Fraud is fraud. It unravels everything. It means the person was never a refugee at all, and he's got it on a fraudulent basis. He should never have been in that position. The answer to that is really dealt with in our printed case, which on these arguments as to absurdity, we deal with their specific examples at paragraphs. I think it's at 66, my lord. Yes. And we say it at 67, really the answer that I've just given. The concern's groundless because such a person wasn't a refugee at all. And there may be the rare case, possibly, one doesn't like to shut out anything, where one might have to face a situation of an individual who is undesirable in other ways, had a refugee status, but has now indulged in activities which now put him in a state where we have to cancel not his refugee status. That may give rise to a particularly different situation, but even there it may be that once one recognizes that he came here as a refugee, he was granted asylum as a refugee, that all human beings are entitled to that basic core entitlement of families that Lord Bingham talked so eloquently about at paragraph 18 of Huang. There may be some rare cases where that situation simply has to be put up with, but there will be ways in which those individuals, those family members, could also be found, could possibly also be refused. But if that is a concern, the Secretary of State can amend the rules in order to put in a rule which actually clearly deals with that. We're dealing with the rules as they are. Well, that's the answer that I give.
Yes, thank you. I think what we'll do now is adjourn until 1:30, and by then we'll be able to see where we are.